Hello. I can't just like test के लिए चलता चलता फिर छूट गया था कहाँ फंसा दिया
morning, ladies and gentlemen. On behalf of the Maharashtra National University, Aurangabad, good morning, ladies and gentlemen. Professor Abdul Hakim, extend a warm and hearty welcome to you all to the inauguration of late Honorable Chief Justice M.L. Pendse Memorial Lecture Series. The chief guest of today's function, Honorable Chief Justice Ravindra Bhatt, former Judge, Supreme Court, will be delivering the inaugural lecture on constitutional dynamism in the 21st century and beyond. Ladies and gentlemen, the Maharashtra National University strives for the overall personal and professional development of its students through various curricular and co-curricular activities. And as a part of this, the university organizes guest lectures, seminars, conferences, workshops, and symposiums on various contemporary legal issues and invites distinguished legal luminaries, eminent academicians, and renowned personalities from all over the country and sometimes even from abroad. It is indeed a great privilege that the university is organizing the late Honorable Chief Justice M.L. Pendse Memorial Lecture Series from this academic year onwards. The objective of this memorial lectures will be to provide a platform for intellectual discourse to the faculty, students, and the legal fraternity at large. This lecture series is basically an exercise to inspire the young minds and motivate them with thought-provoking lectures by distinguished legal personalities. Ladies and gentlemen, Honorable Shri Justice Madhav Lakshman Pendse completed his graduation from Wilson College, Bombay. He later joined the prestigious Government Law College, Bombay to study law. He enrolled as an advocate High Court of Bombay in the year 1958. Government Law College, Bombay practiced to study law on the appellate side, civil, criminal, and writ jurisdiction. He was appointed as additional judge Bombay High Court in the year 1978, and in the very subsequent year, 1979, he was made a permanent judge. He was also the acting Chief Justice of Bombay High Court for some time, and finally he became the Chief Justice of Karnataka High Court in the year 1995. With these few words, I request the dignitaries on the dais to kindly light the sacred lamp. I make a special request to the Chief Guest, Honorable Chief Justice Ravindra Bhatt, to garland the portrait of late Honorable Shri Justice M.L. Thank you, honorable dignitaries on the dais. I request Honorable Shri Justice Abhay S.O. to kindly felicitate the Chief Guest, Honorable Shri Justice S. Raghunathan, former Judge, Supreme Court of India, to kindly felicitate the Chief Guest, Honorable Shri Justice S. Raghunathan, former Judge, Supreme Court of India. Thank you, Lordship. Ladies and gentlemen, I now request our beloved Lordship, most honored Vice Chancellor, Professor A. Lakshminath sir, to make the welcome address. Our beloved Lordship, most honored Vice Chancellor, Professor A. Lakshminath sir, to make the welcome address. Our beloved Lordship, most honored Vice Chancellor, Professor A. Lakshminath sir, to make the welcome address.
Good morning to you all, Lord Chancellor, Honorable Chief Guest, good morning to you all, Justice Registrar, Honorable Chief Guest, Honorable Justice sitting and the dais, faculty and students. Honorable Justice, I heartily welcome you all for this inaugural ML Pendse Memorial Lecture. I heartily welcome you all, and while doing so, on behalf of the Chancellor, on my own behalf, and on behalf of the University, I heartily extend a warm welcome to you all for attending this inaugural session, inaugural lecture, memorial lecture. And I heartily welcome Justice Vasudeva Naik, who has come all the way from Nagpur as a special invitee to attend this. I welcome each and every one, and I am beholden as a special chief guest. I welcome each and every one, and while heartily welcoming chief guest, I express my gratitude to the Chief Guest for having taken pains to give us the printed copy of the lecture. He brings with him the constitutional philosophy, which we can say the liberal constitutional philosophy of the 21st century. Almost we can say a decade ago it started. What is known as the renaissance of the liberal constitutional philosophy. And as is manifest from his recent October judgment, he has penned, I think in MNLU-Chhatrapati, also known as same-sex marriages. He brings in a persuasive constitutionalism, and shows particularly a constitutional maryada, and which he knows abundantly from Montesquieu. He maintains that where almost we can see a conflict as far as the hegemony is concerned. Of course, we know that the Diamond Jubilee of the Supreme Court has been celebrated only on 28th of January. During the first 25 years, the court was able to ask you. The second 25 years, it was transformed to justice. And during the first 25 years of the 21st century, it has been a little bit more dynamic. But what has been manifestly recognized by the chief guest today, that we are going towards this one. Not only that, we have to inject Praja Dharma into Raj Dharma. And he has also advocated the democratic justice, because more than the social justice, democratic justice by ensuring participatory parity of the people and social activists. And this is what we call this Praja Dharma, to be injected into Raj Dharma so that it can be converted into constitutional Dharma. And this is where he has persuasively put constitutionalism, and where he has shown his dynamics also. But at the same time, he has advocated judicial restraint. Because these days there is a lot of criticism on the overarching capacity of jurists or jurisdocracy, I say. But here he has injected this social democracy whereby people's participation and people's mobilization, and these people's mobilization provide a practical reason for legislatures. And legislatures and the people, if they can do, the judiciary can guide them and it can provide an active judicial activism, thereby the constitutional democracy can be established. And this is what is known as redemptive constitutionalism, where we have to bring in constitutional faith, and people should have, we have developed constitutional faith in the people, because they want these values to be established, and the courts are the only medium through which no people expect, because people have got a lot of faith in it. And you see, with these words, I once again welcome all the people, and thank you all, thank you very much. With these words, I once again welcome all the people, and thank you all, thank you very much.
Thank you very much, sir, for your enlightening address. Ladies and gentlemen, it's a privilege and honor for me, thank you very much, sir, for your to speak a few words about Honorable Chief Justice Abhay Srinivas. Privilege and honor for me. His Lordship's illustrious career spans over 4 decades. He started practicing in the Thane District Court in the chamber of his learned father, late Mr. Srinivas W.O. In 1985-86, he joined the chambers of learned father Shri V.P. Tipnis, former judge of the Bombay High Court. Justice Oak appeared in several important matters and also in several public interest litigations. His Lordship was elevated as an additional judge of the Bombay High Court on the 29th of August 2003. On 12th November 2005, His Lordship was appointed as a permanent judge. On the 10th of May 2019, His Lordship took charge as the Chief Justice of the Karnataka High Court. On the 31st of August 2021, His Lordship took oath as the Judge of the Supreme Court of India. Ladies and gentlemen, with great privilege and honor, I most respectfully invite Chief Justice Abhay to make the presidential address. Chief Justice Abhay to make the presidential address. Chief Justice Abhay to make the presidential address.
Honorable Chief Justice S. Ravindra Bhatt, former Judge of the Supreme Court of India, Justice Ravindra Ghugge and Justice Mangesh Patil, Chief Justice S. Ravindra Bhatt, judges of the Bombay High Court who are associated with this university, Justice Ravindra Ghugge, other sister and brother judges of the Bombay High Court, Justice S. Ravindra Bhatt, judges of the Bombay Vasanti Naik with this university, Sri Ravindra Borde and Sri Sunil Deshmukh, former judges of the Bombay High Court, Professor A. Lakshminath, in charge Vice Chancellor, Professor Jadhav, Registrar, faculty members, senior advocates, senior members of the bar, and student judges. Vice Chancellor, Professor Jadhav, Registrar, faculty members. Justice Madhav Lakshman Pendse was one of the eminent judges of the Bombay High Court. After practicing 20 years on the appellate side of the Bombay High Court, he was elevated as a judge of the Bombay High Court. Right from 1985, I had privilege of appearing before Justice Pendse. Unfortunately, only for a brief period, from 1st of April 1995 till 27th of July 1995, he acted as Chief Justice of the Bombay High Court, and then of course, as told by the first speaker, he was appointed as the Chief Justice of Karnataka High Court, and he demitted office on 25th of March 1996. After demitting office, he started practice as an arbitrator. And I must tell, for the benefit of younger generation, that he was one of the most sought after and successful arbitrators. The basic reason was he was very quick in disposal of arbitrations. I must say personally that Justice Pendse was one of my idols. He never sat in the court without meticulously reading files of admission cases. It took only 1 minute for him to understand any complex issue involved in the case after it was called out. He was a very quick judge. He rarely reserved the judgments. If you see his judgments, there are two remarkable qualities about his judgments which are very rare. One quality is that he used to use very simple language which could be understood by all. And secondly, all his judgments are very brief. Today is not the time to discuss landmark judgments delivered by him. I remember in 1986, I was privileged to hear submissions made before him for a while. He delivered a very landmark judgment holding that fraud was played in the results of MD Gynecology examination of University of Mumbai, and whole thing happened at the behest of the then Chief Minister of Maharashtra, and his daughter, who was a student of MD, was the beneficiary. One remarkable thing about this case is, considering the kind of controversy involved, the long arguments, any other judge would have reserved the judgment. But I am told that the moment submissions were over, he started dictating judgments. He dictated a judgment for 2.5 hours on the dais, and ultimately that judgment, the consequence of the Chief Minister stepping down. And therefore I said that he very rarely reserved the judgment. Eventually, the view taken by him was substantially affirmed by the Supreme Court. And therefore, I always say that Justice Pendse was a very fearless judge. Another very important quality which is possessed was, in his court, seniors and juniors were treated alike. In fact, he used to encourage junior members of the bar. He would never hear a senior member of the bar at a particular time of length, because he always wanted to curtail the arguments, but sometimes junior members of the bar were given opportunity. He was very firm, very disciplined, and a very strict judge. There were, of course, quite a few people who said that he was very strict, but my experience was to the contrary. In 1986, one senior member of the bar from Raigad district came to me. He brought a case and he told me that it's a pro bono case, but he wanted me to appear in that case because he said that you will get a lot of experience. It was a case of a poor man who was appointed as a part-time teacher and then full-time teacher in carpentry in one of the schools run by Jilla Parishad in a very remote area. After working for 11 years, his service was terminated. Therefore, he filed a suit for declaration where he claimed reinstatement, etc. He succeeded in civil court and district court. The matter came to High Court. High Court had granted blanket stay. So the lawyer came to me. He said that his man is poor. He won't pay a single farthing for expenditure. But I was more tense because I noticed that the case was coming off for final hearing before Justice M.L. Pendse. And as we were juniors or seniors had told us that he is very strict judge, you have to be more than 100% ready. Then the case was called out around 4 o'clock in the afternoon, or around 4:15. A very distinguished senior lawyer appeared for the Jilla Parishad for the appellant. So he argued for about 15-20 minutes, and I was called upon. I was a raw junior. Whatever preparation I could make, I had made preparation. I had consulted some senior members of the bar. And my turn came around 4:35. And at 4:45, before raising, Justice Pendse told me that, sir, Mr. Oak, you must get undertaking of your client, sworn undertaking, that he will give up back wages for a particular period of, say, 3 or 4 years. And I spontaneously said something which later on I realized that judge may come down very heavily on me. So I said, sir, it is already 4:45. My client is a poor person, and whenever he comes to Bombay, he sleeps at VT station, Victoria Terminus, now it is known as Chhatrapati Shivaji Maharaj Terminus. And therefore now I can't get affidavit affirmed at 4:45 because in those days notaries were not there. And I was taken aback. The moment he heard this, Justice Pendse told me, Mr. Oak, don't worry, you go to Deputy Registrar, I'll instruct him to affirm the affidavit, because in those days, registrars never used to affirm affidavit after 4 o'clock. And he told me that please tell your client to go back immediately. He should not stay here. So this was the nature of Justice Pendse, completely other side. Everybody said that he is very strict, but he was very humane and he had a soft heart. When he went to Karnataka, and he had a very brief term as Chief Justice, and I think he carried forward his reputation in Bombay to Karnataka. I met some of the senior lawyers there who had privilege of appearing before Justice Pendse, and they told me that he is still fondly remembered there, though he was not there even for a year. When I go back to Bombay, I meet some senior lawyers, some of them have retired. Everybody says that you have not seen judge like Justice Pendse for a long time to come. And therefore he has left everlasting impression on the minds of lawyers who practice before him. I am really glad that today we are remembering him, we the members of legal fraternity, the university, and we are having this first lecture in his memory, and very importantly it is on constitutional law. Another important thing, very remarkable thing about Justice Pendse, he was one of the most successful arbitrators in Mumbai. One fine morning, he thought that now he cannot continue as arbitrator. He was very fit. He returned all the arbitration matters and went to Pune and settled down there and started leading retired life. This is something very remarkable. He was on the height of a career as an arbitrator, and he gives up one fine morning the entire arbitration work. In a sense, I was lucky. On 2 occasions, I had gone to Pune, so I went to his residence, and I sat with him for a couple of hours, and he gave me very valuable tips, which were very useful to me in discharge of my duties as a judge of the Bombay High Court. And in fact, today also, I remember those tips, and they are very relevant today also. Today, we have amongst ourselves Justice Vasanti Naik, a retired judge of the Bombay High Court. She was one of our most eminent judges of Bombay High Court. She is here because she is the niece of Justice Pendse. So she is the only close family member of Justice Pendse who is present here. I need not introduce my former colleague in the Supreme Court, my former senior colleague in the Supreme Court, His Lordship Justice S. Ravindra Bhatt. He is well known in legal sphere for his remarkable and landmark judgments delivered by him in Delhi High Court and more importantly in the Supreme Court. He is one judge who was again known to be a very fearless judge, but at the same time very kind-hearted judge. The Vice Chancellor referred to one of his landmark judgments recently delivered in same-sex marriage. But I request the young students to read his judgment, his dissenting judgment. Please remember this. in EWS reservation case where there was challenge to 103rd Constitution Amendment, I always say that this judgment is a class by itself. So I request young students to read this judgment here and spend time on various landmark decisions delivered by him, because we are all eager to hear him. But on personal level, I am very glad that he accepted my request to deliver first Justice M.L. Pendse Memorial Lecture. I am sure that everybody who is present here, they will go back enriched after hearing his address. So on behalf of all of us, I'll thank my colleague Justice Ravindra Bhatt for being here. I thank the team of MNLU Aurangabad for starting this venture. And now every year we may have 1 or 2 lectures in the memory of Justice M.L. Pendse. And I assure you that we'll have all eminent speakers. And now we have started with Justice Ravindra Bhatt, so we have to maintain that standard, and I'm sure that university will maintain that standard. So I thank everybody who is here, and we are all eager to hear Justice Ravindra Bhatt, so I will not take more time. I thank everybody for their presence. Thank you.
Thank you so much, Your Lordship, for your inspiring and motivating message, which all of us here can never afford to forget. I now request Mr. Vishwajit Nimbalkar, President, Students' Bar Association of the University, to introduce the Chief Guest, Hon'ble Shri Justice S. Ravindra Bhatt. Mr. Vishwajit, please.
Respected dignitaries on the dais and off the dais, faculty members and fellow students. Today, I, Vishwajit Shekhar Nimbalkar, President of Student Bar Council of MNLU Aurangabad, is honored and privileged to introduce a luminary of legal world, a titan whose contribution have shaped the very fabric of our contemporary legal system. We are gathered here to welcome a man whose name is synonymous with integrity, wisdom, and unwavering commitment to justice. Esteemed retired Judge of Supreme Court of India, Hon'ble Shri Justice S. Ravindra Bhatt, sir. Honorable Justice S. Ravindra Bhatt, sir, completed his LLB degree from Campus Law Center, University of Delhi in year 1982. Justice Bhatt, sir's remarkable career in legal profession was further cemented when he was appointed as additional judge of Delhi High Court in year 2001. Further, he was appointed as Chief Justice of High Court of Rajasthan in year 2019. Later, on September 23, 2019, he was elevated to position of the Judge of the Supreme Court of India. As we embark this journey into the realm of constitutional dynamism, a topic of immense relevance and significance in today's legal landscape, we are fortunate enough to have in our midst a visionary whose judgments have not only reflected the letter of law but have also embodied its spirit, a spirit that recognizes the dynamic nature of our Constitution and its capacity to evolve with the changing needs of the society. As we reflect on Justice Bhatt's remarkable career, it is impossible to overlook the profound impact of his final act on the bench, the historic judgment on LGBTQ+ rights. Sir stated that recognizing civil union would require a separate regime of law to recognize a bouquet of other rights that are ancillary to marriage, thus upholding the crucial tenets of separation of powers. Sir was also the chairperson of Supreme Court Committee on Accessibility, and his dedication to the cause of disability rights has undoubtedly left a lasting impact. As we are prepared on this enlightening journey into the realm of constitutional dynamism, let us recall the words of Justice Birdsall, words that remind us of the solemn duty entrusted to us as guardians of justice and stewards of the Constitution. Let us draw inspiration from his unparalleled legacy and strive to uphold the principles of equality, justice, and rule of law in all our endeavors. So, it is our honor to have you on the campus to deliver first ever late Hon'ble Shri M.L. Pendse first memorial lecture. Thank you.
God bless you, Vishwajit. Ladies and gentlemen, with great respect, honor, and privilege, I invite the chief guest of today's function, Honorable Shri Justice S. Ravindra Bhatt, to deliver a lecture on constitutional dynamism in the 21st century and beyond. His Lordship, Justice S. Ravindra Bhatt, please.
Thank you. Good morning, Justice Oak, Judge Supreme Court, Chancellor of the Maharashtra National Law University, Justices Mangesh Patil and Justice Ravindra Guge, Professor Lakshmi Nath, Vice Chancellor, sitting and retired High Court judges of the High Court, Senior Counsel, Professor Danaji Jadhav, other dignitaries on the dais, faculty members, dear friends, ladies and gentlemen. It is a singular honor and privilege to be asked to deliver an inaugural lecture. And an inaugural lecture in the memory of Justice Pendse is even more special. And I'm really grateful that you have chosen me and also humbled. Justice Pendse is known for his commitment and devotion to law and his penchant for discipline. All accounts from the Bombay High Court, where he served for the longest time, and the Karnataka High Court, where he was very ably and efficiently led the court, are that he was a stickler for punctuality, discipline, and unwavering concentration. A lawyer once told me that even at the dying moments of a working day, maybe at 4 o'clock, if the court was to rise at 4:30, he would pick up a fresh case and put searching and relevant questions about it. The case might well be number 68 on the day's list. This is the example that he set for himself and for others. He led by example and inspired many generations of lawyers. According to me, he is one among the great jurists who didn't make it to the Supreme Court. And yet his fame is undiminished. In this list, he fittingly keeps company with legends like Chagla, Rajmannar, Judge Learned Hand, all great jurists and great judges. It is truly said that one does not need a label to inspire others. Judges like Pendse etched themselves in the consciousness of successive generations of lawyers by example. They are inspiring figures worthy of emulation. It can be rightly said of him that it is not titles that honor men, that it is not titles that honor men, but men that honor titles. Today's chosen topic of my lecture is constitutional dynamism in the 21st century. Our constitution is now 75 years old. A constitution consists of a set of norms creating, structuring, and possibly defining the limits of government power or authority. Hence, it's very clear that most of the states have adopted their own constitutions, and these are recognized as constitutional states or nations. To be recognized as a democratic or constitutional state, it must have some fundamental means of constituting and specifying the limits placed upon the three cardinal forms of government power: the legislative, the executive, and judicial power. Modern political thought tries to draw a clear-cut difference between constitutionalism and constitution. A state may have a constitution, but need not necessarily be a constitutional state. For example, in the case of an absolute monarch, you may have a constitution, and yet that monarch may exercise absolute and unlimited power. The constitution may confer upon that monarch or ruler. For instance, the greatest example is Hitler. He had all the powers assigned to him. There was a figurehead constitution. He is not legally accountable for the wisdom or morality of his decrees, nor is he obliged by procedures or other kinds of limitations. Thus, what the ruler decrees is constitutionally valid. There is no parallel power to check it. Constitutionalism, in contrast, implies in a sense limited government or a limitation on the government. And you can even say rule of law is a synonym of constitutionalism. It is the very antithesis of arbitrary powers. One concept is rule of law, the other is rule by law. Rule by law means I can change the law as and when I please to suit the person in front of me, to suit the exigencies which arise. Constitutionalism also denotes two types of limitations: power prescribed and the procedure prescribed. It suggests that there are two types of limitations: libertarian and procedural. The states reserve certain areas for fundamental freedom where infringement is hardly allowed. The first 10 amendments to the Constitution of US, the chapter on fundamental rights, part 3 of the Indian Constitution, has outlined this idea. In such a situation, freedom of the individual is protected and its enjoyment guaranteed, subject to certain restrictions for the greater interests of society. Thus, constitutionalism is concerned with two types of interrelated relationships: the relationship between the state and the individual, and the relationship of one government authority with another type of authority. The two types of relationships are not mutually exclusive but interdependent in nature. Apart from distribution of powers, constitutionalism also means another very important thing: a broad separation of powers between legislative, the executive, and the judicial wings. And this is what Montesquieu said way back 200 years ago. When the legislative and executive powers are united in the same person, Hitler, or in the same body or magistrate, there can be no liberty. Again, there is no liberty if the judicial power is not separated from the legislative and executive power, because the judiciary then decides what it does legislatively. Where it is joined with legislative power, the life and liberty of the subject would be exposed to arbitrary control, for the judge would then be legislator. Where it joined with the executive power, the judge might behave with violence and oppression. There would be an end of everything where the same man or the same body exercises these three powers. Montesquieu's separation took the form, if not of impassable barriers and unalterable frontiers, but of mutual restraints, of what afterwards came to be known as checks and balances. The three organs must act in concert, not that their respective functions should never touch each other. If this limitation is respected and preserved, it is impossible for that situation to arise, which the jurists Locke and philosopher Montesquieu regarded as eclipse of liberty, the monopoly or disproportionate accumulation of power in one sphere. The main aim behind the principles is to protect people against capricious, tyrannical, and whimsical powers of the state. It is acknowledged that the nature and extent of federal governance of a political system is closely connected with the changing perspectives of social, economic, and political dynamics. How the governing process is institutionalized in the basic document, which is the constitution of a country, may not at all be consistent with the changes that take place over some periods of time. Changes are bound to occur as there might be changes in the nature, working, and direction of the political system, the evolution of institutions, challenges posed by rapid industrialization or impact of climate change, or even economic realities. These changes take place as societies encounter new situations, new demands, new compulsions, and consequently the political system has to find new ways of responding to these external and outward changes. Thomas Jefferson, one of the founding fathers of the American Republic, who also was its third president and author of its Declaration of Independence, said, and he said it very radically, I am not an advocate for frequent changes in laws and constitution, but the laws and institutions must go hand in hand with the progress of the human mind. As that becomes more developed, more enlightened, as new discoveries are made, new truths are discovered, and manners and opinions change, with the change of circumstances, institutions must advance also to keep pace with the times. We might as well require a man to still wear the coat which fitted him when he was a boy, as a civilized society to remain ever under the regimen of the barbarous ancestors. He called constitution makers barbarous ancestors, and yet the Constitution of the United States endures for almost 250 years. Of course, there have been great changes in their society, as also ours. So I'll come to my main thesis that there are changes, and our Constitution is not as rigid as the US Constitution. It has an inherent dynamism which allows moving parts and to assimilate and these changes and rise up to them. The Indian Constitution is regarded as a symbol of social aspirations rather than as the formalized rules for the exercise and control of political power. But equally, it is true that the political system which is described in the Indian Constitution seems to be more evolutionary than revolutionary. That is the inherent dynamism which we have, that the Constitution doesn't bring about a change like a gunshot from a pistol. It allows change to happen incrementally. Hence the framers added a component of dynamism and modernism by specifying the goals and objectives of the state in the preamble and the directive principles of state policy. Equality, liberty, our freedoms, fraternity, and justice in all its shades and forms. And it established the process or instruments necessary for the attainment of these goals. Then the Constitution is supposed to apply Granville Austin's famous phrase, a vehicle for social revolution. These should under no circumstances be seen as merely normal aspirations of a civilized society. These thoughts seek to provide for the creation of a modern society and a modern political system through democratic institutions. Then, taking into account the variety in the essential circumstances presenting after the independence, the Constitution tried to effect a curious compromise between contradictory principles. Our Constitution, which has been drafted, has some deviations and contradictions. These deviations, till the first early years of our republic failed to endanger the stability of the political system itself. After the emergence of the national political centralization during the mid-60s, some of the explosive issues assumed the proportions of a serious confrontation between ideologically differentiated political forces. Due to these challenges, the Constitution has been able to keep itself in working order with surprising degree of adaptability to the changes. The amending process, which takes together the virtues of stability and order and progress, is another factor in the dynamism. Each generation views the same document from different lenses. The Constitution has the potential to offer a fresh perspective and a platform for serious reflection for the citizen, the judge, the practitioner, the policy and lawmakers. A living constitution, which is what our courts have repeatedly described it as, is expected to adapt to the changing times and contexts, even if it means giving up some of the old doctrines that shaped its original identity. This need or change is addressed through revisiting laws, updating them to meet emerging challenges, calibrating public policies, and whenever needed, modifying or even changing and replacing institutions or entities to address the concerns and efficiencies required to cater to those situations and developments. This change is also acknowledged and addressed by the judicial system through clarification and overruling of precedents if the existing judgments create barriers in accommodation of new developments. Precedents are not to be overruled lightly, given that the legislative bodies may not have changed the governing substantive law. The courts apply a robust and rigorous set of principles to determine whether the injury to the public is greater if the previous allowing or decision is allowed to continue, or whether the new principle sought to be substituted itself may create uncertainty. A judge of the South African Constitutional Court, Justice Pius Langa, points out that any change brought about would be a transformation that would have a strong societal and cultural basis, and offers the following words from the epilogue to the interim constitution of South Africa as the basis for the South African brand of transformative constitutionalism. A historic bridge between the past of a deeply divided society characterized by strife, conflict, untold suffering and injustice, and a future founded on the recognition of human rights, democracy, and peaceful coexistence, and the development of opportunities for all South Africans, irrespective of color, race, class, belief, or sex. Here it is essential to understand that the transformation aimed at is not merely meant to secure basic social and economic political rights, but to ensure the holistic and larger aim of elimination of grassroots inequalities in terms of access to means, opportunities, education, livelihood, and justice. Another former Chief Justice of South Africa commented, "As long as these conditions continue to exist, the aspiration of substantive equality will have a hollow ring." In the pursuit of this ideal of transformative constitutionalism, aside from the legal and economic transformation sought to be achieved at the macro level, a different conception of the process of transformation has also been offered, which is the process should not be seen as having any definite end, meaning thereby that if transformation is viewed as a temporary event, then what is envisaged is that there will come a point when transformation shall be achieved, whereby the process would end. However, the alternative conception, in terms of our society, just to make it more understandable, it is not that the aspiration is to have a vehicle. If someone has only a cycle, he might at some stage have aspired to own a scooter. But that doesn't mean that his aspirations would stop. If cars have become cheaper and he is able to afford either he has the means himself or he is able to afford afford cheap credit, he would want a car. And why not? These aspirations should not remain aspirations. This is what the judge is saying here. That takes us to the methodology of accommodating or addressing change. The first and obvious method of change is through the amending process. The jurisprudence of this country has shown some changes in the amending process and how it has been seen. Till 1967, the Supreme Court ruled that there were no restrictions in regard to the amending power of Parliament. For the first time in 1965, in Sajjan Singh, 2 out of 5 judges expressed reservations whether Parliament at all had the absolute power to amend any part of the Constitution. Justice Mudholkar and Justice Hidayatullah, who were also from Maharashtra. In Golaknath, the court ruled by a majority that Parliament's power to amend the Constitution is limited to the extent that it cannot abridge or abrogate any of the fundamental rights under Part 3. This brought about some problems because there were laws, agrarian laws, which sought to achieve social justice and equality to those who were have-nots. Now, those laws had to be protected, otherwise they fell under the bus, so to say, of Article 14 or Article 19. Therefore, the Supreme Court realized that and corrected itself 6 years later in Keshwananda Bharati, which by a majority held that Parliament could exercise its power to amend any part of the Constitution, but not so as to alter its essential or basic features. This judgment has withstood the test of time. It has been invoked nearly 60 times through challenges to the constitutional amendments made over a period of time. However, only in 7 cases the Supreme Court has held some provisions of the amendment to be violative of these essential features. And a majority of them, I think 6 out of 7 have been with respect to judicial review. Aside from this celebrated example, the dynamism in constitutional interpretation is illustrated by the number of times, the innumerable times the Supreme Court has corrected itself and changed or overruled a previous ruling. Some prominent judgments are Indira Sani, which overruled Balaji and held that Article 16.4 is not an exception to Article 16.1. This is because the Constitution has Article 141, which is a peculiar feature of our Constitution, which provides that the law declared by the Supreme Court shall be binding on all courts. This was first held, the theory of overruling was first propounded in Bengal immunity. The Supreme Court said that its judgments could be overruled by later benches if the situations so warranted. That is a recognition of the dynamism which our Constitution provides. The court said that it is not easy to amend the Constitution if the court interprets the Constitution wrongly, and there is nothing in it barring it from revising or overruling its previous decision to correct the error and prevent public mischief. The test which the court applies in all cases before overruling another judgment, and this is applicable not only in the Supreme Court but in all other high courts. The sitting judges, Justice Oak and sitting judges of the High Court are very well aware that just because one judge or a few judges have a different view, you don't go and upset a previous ruling. Let's say the older the ruling, the more the sounder it is seen, unless there is a fundamental change in the law or a fundamental change in the understanding in society. Supreme Court and High Courts have time and again corrected the errors, either due to difficulties arising because of the judgments in question or because of new developments which necessitate review of the previous precedent. This represents a very important facet of dynamism and accommodates and assimilates change. Another dimension of the dynamism, which is the main theme of today's lecture, of our Constitution are provisions relating to elections. I give you this example as it illustrates how institutions and provisions of the Constitution evolve dynamically and adapt to the needs of the time. These provisions have ensured one election regulating body for the entire country, which is the Election Commission, whose members are given a high degree of tenure security. The Chief Election Commissioner is given the same protection in terms of removal from office as a Supreme Court judge, 2/3 majority in Parliament and addressed by the President, to the President. The same process. Furthermore, it is one set of laws, like the two Representation of People's Act 1950 and 1951, which regulate elections and spell out the rights and obligations of political parties and their candidates, qualifications, disqualifications, timelines for declaring candidature, disclosure, etc. They also provide the entire code for the manner of conducting elections and dispute resolution during elections and after. There are provisions in the Constitution which also ensure that once begun, an election process cannot be interfered with even by the courts. The Supreme Court's supplementary role of interpreting these provisions, like Article 329A in N.P. Punnaswamy, an old case, and arming the Election Commission with overriding powers, like in the Mohinder Singh Gill case, also played an important role. This supplementary role illustrates the dynamics of constitutional interpretation and injects a kind of concordial or cooperative approach of constitutional institutions with each other. Provisions like Article 324 enable the Election Commission to issue directions. In the Mohinder Singh Gill case, this is what the court said, that the Commission is a high-powered and independent body which is irremovable from office except in accordance with the provisions relating to removal of judges of the Supreme Court, and is intended by the framers to be kept completely free from any pulls and pressures that may be brought through the political influence in a democracy run on party system. Once the appointment is made by the President, the Commission remains insulated from extraneous influences, and that cannot be achieved unless it has amplitude of powers in the conduct of elections, of course in accordance with existing laws. But where these are absent, mind you, this is very important, where laws are silent and yet a situation has been to be tackled, the Chief Election Commissioner has not been told to fold his hands and pray to God for divine inspiration to enable him to exercise his functions and to perform his duties or to look at any external authority. He must lawfully exercise his power independently in all matters relating to the conduct of elections and see that the process is completed properly in a free and fair manner. Therefore, the Commission, due to these provisions and supportive role of the courts, has since the 1990s played a very proactive role and fashioned a code of conduct which binds parties and governments, preventing huge policy changes in the eve of elections. You are familiar that just before the elections, the government in power cannot make any policy changes, make important policy changes, and announce new schemes, all because of this code of conduct. And the beauty of it is that the code of conduct does not have the authority of law, and yet, why is it respected? Because all parties stand to lose. One or the other party, either in opposition or in power, will stand to lose if they violate it. So they accept it as the rule of law laid down by the Election Commission. Then there are other provisions which prohibit exit polls results publication during elections, and also prohibiting campaigning days before the polling. All of these have been achieved progressively over a period of time. Parties have accepted these unreservedly as the rule of law during the elections. Many of you students, of course, will not even be aware, and possibly many teachers also, young teachers, that till the mid-90s, voter intimidation and terrorization, rigging and violence during elections were widespread. All this stopped because the Election Commission started asserting itself. Its sweeping powers include the right to move personnel and not look at state government or the central government, but in fact issued directions to them to transfer their officers suspected of being partial. Direct movement of the Commission can direct movement of paramilitary forces to safeguard and secure the election process till counting and announcement of results. The entire machinery is controlled by the Election Commission, which has a complex network of officers trained and vetted meticulously for their impartiality and independence. Now just visualize what is happening in the United States in the absence of these provisions and a collaborative approach. The Supreme Court as the evolution, or the Supreme Court's collaborative evolution and the unitary law of elections, to keep it on one side, Indian example or the Indian experience, compare it with the US. If it were not there, this could have resulted in election-related allegations which are haunting even the largest of what is proudly proclaimed as the oldest modern democracy, US. Even a situation like Bush versus Gore, where in 2000 the US Supreme Court had to virtually decide who was the winner of the presidential election. The Supreme Court's decision was among the most controversial in US history and virtually split along party lines, because 5 of the judges who constituted the majority belonged to the party which ultimately held in favor of President Bush, who became President Bush. And 4 of them they were nominees of a democratic government or different Democrat. We don't have that. Why? Because the Constitution and our Parliament was in its initial days was wise enough to bring a unitary style, a unitary system where all elections are controlled by the Election Commission. You don't have a set of unitary laws in the US. You have 50 laws of elections, 50 ways of counting. We have one way of counting votes. We have one way of securing the voters' rights to cast their vote. They do not have it. So even yesterday, the US Supreme Court heard a case where the Colorado State Court had bumped off the candidature of President Trump. They said that he is an insurrectionist, which is a rebel. During the 2020 aftermath of the elections, he was a conspirator according to some accounts. He's facing trial, but the Colorado Supreme Court bumped him off and said his name cannot be on the ballot box in Colorado. So one of the main arguments, even by the nominees sitting on the bench from the Democratic nominees, they all felt that if every state is to be given this power, then even the present incumbent, Biden, might also be bumped off by several states. So this is the chaos that they have in the US, which they have not been able to rectify, but our constitution makers thought about a new institution, the first of its kind probably, which has been clothed with. Of course, there are always controversies surrounding every institution, and the Election Commission has gone through them. And yet, some of its practices have been robust and it has stood the test of time. In the field of economic and commercial policies, the same constitution has accommodated different economic philosophies. The flexibility that lawmakers and policymakers enjoy in this country is tempered by the fundamental rights of the people and also the directive principles, which the Supreme Court has emphasized is the conscience of the Constitution and directs elected rulers to always keep at the forefront the needs of the people and their welfare. Therefore, in the early years of our Constitution, the dominant economic philosophy was a controlled one, with some space for the private sector to propel state-oriented growth. The thrust and direction of our country was defined by the industrial policy enunciated in 1951, and many of the laws enacted at that time. Then began the second phase in the 90s, when the government went into a nationalization spree of large corporations. These were in the banking, insurance, petroleum, gas, electricity, and other infrastructure and key segments of the economy. It was later realized that increasing globalization and hence the move to open economies in the world order, which began in the 80s and ultimately culminating in GATT and eventually the WTO, required adequate response, or this country would lose economically. Coupled with the alarming foreign exchange situation, the then elected Narasimha Rao government took a stand which virtually opened the economy. While not quite entirely, but in all key segments, private and foreign investment was welcome. The industrial policy was rolled back and many laws were amended or even completely repealed. Disinvestment, that is, public sector disinvestment, began and has continued even today. This change was not unchallenged. The first disinvestment was questioned in the Supreme Court, which said that the Constitution doesn't subscribe to any one economic philosophy, and more importantly, that the courts will give more deference to the economic laws concerning the economy, which cannot be lightly challenged, because the government has the right to trial and error method in these areas. Foreign exchange restrictions were largely relaxed to allow repatriation of returns of investors. This led to the state retreating from the economy and state enterprises also retreating, resulting in private companies and enterprises transacting in almost all areas. The third generation of economic reforms has been a regulation and trying to enact a series of regulatory laws which level the playing field to make it more competitive. Therefore, there are regulatory bodies in the infrastructure areas like telecom, airports, energy, and most importantly, competition, and so on. This was to ensure that there was fair play at the marketplace and market forces did not apply so to the detriment of the consumer and citizen. It could be argued that many of these institutions or regulatory bodies have not really performed up to the remit that they are expected to, but that's for us, the courts and citizens, to question the government about the people that staff them, about the transparency that they have and the decisions that they make. But those institutions are there. These regulators find a regulatory approach where the government itself is not a player but a regulator finds resonance in Articles 38 and 39. The very same articles which the Supreme Court held cast obligations upon the state to ensure that the greatest good for all people, for all the citizens of the country, was ensured. The move in the opening of the economy when needed, restricting entry and regulating it, has continued today. Apart from the economy, the movements and developments in constitutional law, not only in terms of interpretation of the constitutional provisions, but the way access to justice has been fashioned and visualized, and in terms of awareness brought about through these judgments, are evidence of dynamism. The need for transparency and the citizen's right to know her or his government, how his government functions, its inner workings, and how decisions are taken, and its process was highlighted. This began in a peculiar manner when in the Association for Democratic Reforms, the court said, in a nation wedded to republican and democratic form of government, where election as a member of parliament or MLA is of utmost importance for government, whether before the casting votes, voters have a right to know the relevant particulars of their candidates. This was decided by the court, which said, yes, you have to declare your criminal antecedents. And the court underlined that everyone who aspires to hold elected position had to necessarily disclose involvement in a criminal case. And its outcome led to the information movement, eventually the enactment of the Right to Information Act. Though there have been some rollbacks in terms of amendments to this act, it has added a new dimension to our constitutional democracy in terms of rights of people, which have got enlarged and about the right to know about the inner workings. Apart from these, in the early 80s, you had those seminal judgments like S.P. Gupta, which opened up the vistas for a common man to approach the Supreme Court with public causes. Of course, it has its flip side, and judges, both sitting and retired, know the flip side of it, that you get all kinds of litigation. But then, in a democracy where accountability is a very important and key element, the accountability sometimes does not happen through statute. Where the government or the bureaucracy does not perform, there is inaction. Invariably, the pressure and the burden lies upon the court. The citizen turns to the court and says, what is happening there? What is happening in my neighborhood? And you can't turn them away. Some of them could be frivolous, some of them could be malicious, but that's the burden we carry. And we cannot turn these citizens away. But the important point is the gateway, the pathway was opened by the Supreme Court in 1982. Then if you go forward, there are many other judgments like this. The right to food, which eventually led to the Food Security Act. Then you had the minimum guarantee, the MNREGA policy, which was evolved by the state, but initially started with the court directing midday meals in a public interest litigation, PUCL. All these are achievements which our democracy should be proud of, because these are not controversial. All governments have accepted the minimum principles behind this and acted upon it. Likewise, the right to education, right to universal basic education, which was declared way back in Mohini Jain in 1991. It took time for the amendment to take place, but it became an amendment in the Constitution. It's become law in terms of Right to Education Act. And of course, the courts have to play a very proactive role in ensuring that it is achieved, its objective is achieved, and it's a work in progress. There are several areas, like for instance, constitutional amendments, which sought to bring about more reforms in India. In governments, by the introduction of the 10th schedule in 1985 to deal with the menace of defections in parties. This amendment you have heard, or if you have not heard, there was this famous phrase called Ayaram Gayaram. Now, Ayaram Gayaram is almost legendary because it actually refers to one Ram. One Mr. Ram had the infamous or dubious distinction of changing parties 21 times. He belonged to Haryana. And in one particular day, he changed 3 parties. So to curb that menace and ensure that there was some element of discipline and cleanliness in the polity, this amendment was challenged. Now there are problems in it, and I think the Supreme Court has reserved its verdict in a 7-judge judgment on the interpretation of some parts of the 7th schedule. Similarly, the introduction through constitutional amendment of local self-governance through panchayats under the 73rd and 74th amendments, and further amendment in the constitution with respect to the cooperative movement, and lastly the introduction of a unified indirect tax regime, which the indirect tax regime, or the GST, which brought in an entirely new concept. Till today we had what is known as a state sovereignty and central federal sovereignty. Now we have a new concept of both parties, the center and the state, sharing a power, and it's called pooled sovereignty. So in this sphere of indirect taxation, there is one law, one institution, not even parliament, not state legislature. The GST Council is virtually the rule-making authority which sets out, okay, these are the principles by which state laws can be enacted. These are the principles by which central laws can be enacted. And GST Council is sought to be made a very as democratic as could be politically possible, which is that the voting in the GST Council is weighed 2/3 in favor of the state and 1/3 in favor of the center. So the center gets 1/3 vote and the states put together get 2/3 vote. And yet no decision can be taken except by a 3/4 majority. So this is how decisions are taken, and based on those decisions, the concerned legislatures act. Parliament or the states can enact those laws based on those principles. Our constitution is unlike the Soviet Union. It is also unlike the United States Constitution, which enacted certain structures dividing the powers horizontally and vertically. The legislature, executive and judiciary on the vertical side, each seeking to check on the other's excesses. Our powers are horizontal in the sense that the federating states on the one hand and the central or federal government have separate powers. The only restrictions are these, which are fundamental rights. Yet, the fundamental difference is Americans did not see the need to change their society. They had slavery for the longest time. It took a civil war to change that. And yet, another 70 years till actual legal equality could be achieved. Although you had the 14th Amendment in the 1860s, the US Supreme Court decided that equality means one thing for the whites and equality means another thing for those who are not white citizens. And equality meant for the longest period of time no equality for women. In fact, the women got a right to vote much later than us. They had their Civil Rights Act in 1965. At the inception of our constitution, we brought in a revolutionary change in the sense that we wanted a vote for all our citizens. At the inception during our independence movement, we were acutely conscious that not only do we have to gain Swaraj from the foreign ruler, but also internally, there had to be democracy and a society which ensured social and economic justice and equality of all her people. The other challenge with the independence movement encountered after independence was that not only British territories, but there were 500 or more, 520 odd local rulers, some big, some large, some medium-sized, some very, very small, few villages. And each of them had their own governing structures, their own courts, their own legislatures, their own bureaucracies. On a very lighter note, when the state of Madhya Pradesh was being put together out of many other states, Vindhya and other regions, Bundelkhand regions, there were many states. One of those small states was headed by a police. The police chief was called the Inspector General. Now, when it became Madhya Pradesh, unfortunately for that gentleman, the state's reorganization enabled the state and the center to integrate the services. So this gentleman from Inspector General lost his generalship. He became an inspector. So this was the transformation that we achieved by dint of the efforts of our freedom struggle and our initial visionaries like Sardar Patel and V.P. Menon, who tirelessly worked to integrate, and this was no mean achievement because this constituted nearly 50% of the entire territory of India. So to bring them into one fold and come out with one constitution, with one vision, just imagine, it was not an equal society, it was not a uniform society, it was in every senses of the term most diverse. Of course, it was plural in the sense that there were different cultures, there were different religions, different languages. And yet, the diversity of its ruling structures was truly astonishing. The constitutional project envisioned that the people's will had to prevail not only in the sense that the people's choice had to be respected in terms of electoral outcomes, but that elected rulers had to abide by certain basic principles while making policies and laws. This was the conscience of the Constitution. This part 4 sets us apart from the US and all other constitutions which gave or require the governments to ensure the greatest good is enjoyed by all. In every democratic polity governed by written constitutions, it is a given that the courts have to play the role of the ultimate arbiter as to what its provisions mean. Thus, that the courts do not look at these provisions in a rigid manner. Although the history of the provision is taken into account, that is only one consideration. The courts also invariably look at how it has been interpreted in the past and whether the interpretation is served by the nation and its needs. We have therefore rules and principles of interpretation which allow the same provisions of the Constitution and laws to be interpreted in the light of the changing times. I'll just give one example. This is what Justice Patanjali Shastri said in V.G. Rao in 1952. I call that a classic which has not been bettered. And this is what he said. Even ideas of what is just differ from age to age. What may be seen as just to one man in one age may appear to another man in another age as the very quintessence of injustice. Just visualize, in 1950, you could not seek a writ of mandamus against an administrative decision. It took 20 years for the Supreme Court to say that even administrative orders are amenable to writ. In deciding the reasonableness of restrictions, this is very important. It is not possible to think only in the abstract. Several circumstances must be taken into consideration, in particular the purpose of the enactment, the conditions prevailing in the country at that time, the duration of the restriction, its extent and nature. What may undoubtedly be a reasonable restriction in a state of war or revolution may be utterly unreasonable in normal times. What may be a reasonable restriction if it is for a short period may be unreasonable for a much longer period. Therefore, following from this kind of ruling, we also have other principles. If the Supreme Court said something in 1960 that this is reasonable or this is does not offend Article 14, there are at least 7 or 8 judgments which say that passage of time might render it violative of 14. There are some recent judgments also. Likewise, the concept of arbitrariness evolved through several decades of interpretation. The concept of fairness, which has been injected into almost all branches of administrative law and has seeped into the law of constitutional and statutory interpretation, has given a humane dimension to our laws. The need for a minimum hearing before an adverse order is made is an integral part of all branches. These principles and canons of interpretation and understanding the context in which the law is made requires the court to apply their mind in almost every new case, in every new statute to the prevailing times and the need for such policy. All these underline the dynamism which our Constitution has accommodated. It is only where the courts discern that the law or policy has gone too far and encroached upon the people's rights that the courts intervene. Its role is that of an umpire who stands at the boundary and guards people's rights and decides the causes before them. Our society is facing unprecedented challenges, social, economic, and environmental, driven by accelerating globalization and a faster rate of technological development. At the same time, these forces are providing us with new opportunities for human advancement. The future is uncertain and we cannot predict it, but we need to be open and ready for it. All of you, my dear students and members of the faculty, will be discharging significant responsibilities 10 years hence, maybe 20 years hence. Today's institutions of learning can prepare students for jobs that have not been created, for technologies that have not yet been invented, to solve problems that have not been anticipated. It will be a shared responsibility to seize these opportunities and find solutions. To navigate through such uncertainties, the students have to develop curiosity, imagination, resilience, and self-regulation. They will need to respect and appreciate the ideas, perspective, and values of others. They will need to cope with failure and rejection and move forward in the face of adversity. Their motivation will be more than just getting a good job and a high income. They will also need to care about the well-being of their friends and families, the communities, and the planet. It is crucial that education that our institutions provide should equip learners with agency and a sense of purpose and the competencies they need to shape their lives and contribute to the lives of others. In the face of an increasingly volatile, complex and ambiguous world which this planet has become, your education has the potential to make the difference whether people embrace challenges that they are confronted with, or whether you are defeated by them. In an era characterized by a new explosion of scientific knowledge and a growing array of complex societal problems, it is appropriate that curricula and methods of teaching should continue to evolve, perhaps radically. Our societies are changing profoundly. The first challenge is environmental. Each of these challenges also pose direct or indirect challenges to the way of life and our constitution. The first challenge is environmental. Climate change and the depletion of natural resources require urgent action and adaptation. Managing environmental sustainability and preserving natural resources. Environmental sustainability and preservation of resources will be important constitutional challenges in 21st century as the government seeks to balance economic development with the need to protect the environment and conserve natural resource. You already see the effects of this climate change. Migration, displacements. Every second year Mumbai has floods. Even a place like Gadchiroli was waterlogged. And Chennai, Mumbai, all these coastal cities are bearing the brunt of this climate change. Others in the north are also not immune to it. The mountains. Himachal last year, Himachal Pradesh saw the worst of rains and landslides. The second challenge is economic. Scientific knowledge is creating new opportunities and solutions that can enrich our lives and at the same time fueling disruptive waves of change in every sector. People can lose their jobs, become irrelevant, and the pace of this change is such that people have to adapt at a pace which is we are not prepared for. Unprecedented innovation in science and technology, especially in biotechnology and artificial intelligence, is raising fundamental questions of what it is to be human. It is time to create new economic, social and institutional models that pursue better lives for us all. There has to be a new framework, a new dialectic. Financial interdependence at local, national and regional levels has created global value chains and a shared economy, but also pervasive uncertainty and exposure to economic risk and crisis. Data is created, used and shared on a vast scale, holding out the promise of expansion, growth and improved efficiency, while posing new problems of cyber security and privacy protection. Another challenge is social, that is, as global population continues to grow, migration, urbanization and increasing social and cultural diversity are reshaping the countries and communities. Other challenges and concerns which face us are that while the Constitution enshrines a number of individual rights and freedoms, also providing for measures to so provide and promote social welfare. To balance these competing interests will continue to be the biggest concern in the 21st century. One more is that federalism and central state relations. Our constitution establishes a federal system, but there have been ongoing debates about the distribution of powers and finances between center and the states. Protecting civil liberties and personal freedoms in these days of change, in these days of potential loss of privacy every turn of your life, and protecting the guarantees such as fundamental rights to free speech, expression and association will also be big challenges. However, these rights are sometimes threatened by government actions, and sometimes other actors, even private sector or private agencies continue to threaten these rights, because we are living in a privatized economy, in a privatized world. In large parts of our country, inequalities in living standards and life chances are widening, while conflict, instability and inertia, often intertwined with populist politics, are eroding trust and confidence in government itself, in institutions. At the same time, the threats of war and terrorism are escalating exponentially. Such global trends are affecting individual lives and may do so for decades to come. Unless steered with a purpose, the rapid advance of science and technology may widen inequities, exacerbate social fragmentation, and accelerate resource depletion. An American jurist, a great one, Oliver Wendell Holmes, said that the Constitution is an experiment, as all life is an experiment. Every year, if not every day, we have to wager our salvation upon some prophecy based upon imperfect knowledge. Ambedkar said it differently, speaking how durable a constitution can be. He said, however good a constitution may be, it is sure to turn out bad, because those who are called to work it happen to be a bad lot. However bad a constitution may be, it may turn out to be good if those who are called to work it happen to be a good lot. The Constitution can provide us only the organs of state, that is the legislature, executive and judiciary. The factors on which the working of these organs of the state depends are the people and the political parties they will set up as their instruments to carry out their wishes. The inherent dynamism in our Constitution, I would say in conclusion, should not mean that it is meant to have a shelf life. We can't have one Constitution every generation. Its provisions may seem limited. If so, they are constrained only by their letter. So what is written in them only constrains you. But if you think of it as a possibility, as many Supreme Court judgments have said, the Constitution is only a framework. So it's not the letter of the law, but it is the spirit of the Constitution, the ideas, the values that it inculcates, which should continue to inspire and guide us. The spirit of liberty, of freedom, of equality, fraternity, justice in all its shades, for all, and above all, the democratic principles. If we do not keep faith in the Constitution and work it, the precious freedom we gained through sacrifice of countless countrymen in every sense would slip away. It is upon you, my young friends and teachers, to carry forward these values and realize its goals and foster an unwavering constitutional culture. Thank you.
We are extremely grateful and thankful to your Lordship for your immensely enlightening and extremely informative lecture. We got to know so much, not only about the Indian Constitution and Indian judgments, but also today we got to know so much about the American Constitution and the American judgments. Your Lordship, your suggestions and guidelines to the students and the faculty members are highly appreciable. Ladies and gentlemen, now to conclude the program, I request Professor Dhanaji M. Jadhav, Registrar of the University, to kindly propose the vote of thanks.
The dignitaries on the dais, ladies and gentlemen, I am standing before you with the utmost humility and great privilege to propose vote of thanks of this first Let ML Pendse Memorial Lecture. At the outset, I thank to Honorable Justice S. Ravindra Bhatt, former Judge, Supreme Court of India, who consented to deliver the first Let ML Pendse Memorial Lecture. Thank you, sir, for accepting our invitation and making it convenient to be the chief guest of today's function. When rule of law is considered to be the sine qua non of a democracy, the Constitution and constitutionalism assumes the great significance in constitutionally elected government and its functioning. Your practical insight, articulation of an academic exposure has really added many things to our knowledge. Thank you very much for your illuminating address. We have been really enriched academically by your speech, and it has left many things and food for thought in future. Idea to conduct the lecture series as an academic exercise was of our Honorable Chancellor, Honorable Sri Justice Abhay Oak, Judge, Supreme Court of India, who is really working hard to develop this university with academic exposure as well as architecturally. Thank you very much, sir, for your presidential address. I am also thankful to Honorable Justice Ravindra Guge, Administrative Judge, High Court of Bombay, Chairman of Building Committee, Chairman of Finance Committee, Member of Executive Council, and General Counsel of Maharashtra National Law University, Aurangabad, for his constant support and guidance for meticulous planning and execution of this event. I am also thankful to Honorable Justice Mangesh Patil, the Member of the General Council, for his most valued and gracious presence. We are really gratified by the presence of Honorable Judges of Bombay High Court sitting and retired for their most valued presence. I am also thankful to all the designated senior counsel, principals of the law colleges, academicians, and the faculty members for their presence. I would like to place on record my sincere thanks to Honorable Justice Vasanti Naik, Honorable Justice R.M. Borde, Honorable Justice Sunil Deshmukh for their constant support and guidance during this entire event. The event of this magnitude required cumulative and common efforts so as to produce uncommon result. For organization and meticulous planning, there was student volunteers and faculty team which was working hard strenuously since last 2 weeks. I thanks to all the faculty members for their direct and indirect support. I also thanks to all the students participants volunteers, and students, those who are actually the participants of the moot court competitions organized by Maharashtra National Law University, Aurangabad, for being with us. Thank you very much.